Today we're with David Shapiro. David Shapiro is a criminal defense attorney in San Diego, California. He's agreed to answer some online questions. If you're one of the people who posted a question, you'll have your answer right now. If you're just finding this video and you're looking for a criminal attorney in San Diego or Southern California, feel free to give him a call, or if you have a direct question, you can actually post it to the bottom of the YouTube video, and David has agreed to answer your questions directly. With that said, David, let's go to the first question that was posted. I have a misdemeanor drug charge. Do I still need a criminal attorney?
Yes, you definitely still need a criminal attorney if you're faced with any criminal charge. The main issue is whether or not you are eligible for court-appointed representation, more likely than not the public defender's office. What I mean by that is you're determined to be indigent or basically unable to afford an attorney, but the court already qualified for court counsel. So you can't have a lot of money and just say, oh, I'm going to roll with the public defender. But you definitely need an attorney. The issue is, will you hire an attorney if you have the means to do so, and will you hire the right one? That's importantly the real question in this. And, you know, sometimes a lot of people misdemeanor, what's going to happen? I can get a year in jail, probably not too realistic, and other consequences of a misdemeanor drug charge. And you want to make sure that you have some choice and some control over the attorney that represents you in court, the attorney that's negotiating with the prosecutors on your behalf, and just in general, the person that's representing you. A lot of people hire attorneys that, you know, for lack of a better word, clowns, prepared, have no respect from their fellow attorneys, district attorneys, city attorneys, and judges. So it's important definitely to hire the right attorney, but you definitely do need an attorney.
Okay. The next question was, I'm in the military and received a DUI. Can I seal this information, or is it going to go public?
Well, when you say received a DUI, I'm assuming you mean arrested for a DUI. How it works in California is this. Irrespective of whether you're in the military or not, the arrest is public record for the most part. The court case will definitely be public record. What I mean by that is, even if you get a case filed against you in court, not just arrested, filed in court, where you have to go to court or your attorney goes to court to defend against the charges, there will be a court file that anybody could go up to and give your name and date of birth if they know it, or a case number, and be able to inspect most, if not all, of the contents of that court file. The issue is going to be, well, does the military need to know in this case? That's ultimately between you and them. You know, my position is I'm definitely not going to call them unless, you know, they know about it anyway, and we could get some letters or some documentation that'll actually help your case. On occasion, I've seen law enforcement contact the military, superior officers, when they've arrested someone in the military, which I think is a little ridiculous and unnecessary. But, you know, the court file will always be public record for the rest of your life, even if the case is dismissed, even if you are granted what's commonly referred to or misreferred to as expungement relief under 1203.4 of the Penal Code. It's still public record. It'll show that the conviction was set aside, the case was dismissed under Penal Code section 1203.4, but there's still a court file. You know, we think expungement, we think, you know, so on like your computer, if you trash it, like they throw it off, in this case, the Coronado Bay Bridge. It just doesn't happen like that. The file remains, it's still public record, for better or worse.
Okay, all right. This one's directly to you. Do you offer payment plans?
Yes, we definitely offer payment plans. They need to be realistic payment plans, and a lot of that depends on the type of case, the location of the case, where in California, where in San Diego particularly is the case, the severity of the case, the severity of the potential client's record, and the total overall fee. You know, obviously I'm running a business here, and it wouldn't make a whole lot of sense, and it doesn't make sense, that's why I don't do it, to put payment plans out that exceed the duration of the case. Meaning, if I think a case is going to take 4 months, I'm not going to put someone on an 8-month payment plan. That's just bad business. At the same time, though, I have the opportunity to be flexible because it is my business and everything gets overseen by me, where I could say, hey, listen, you know, I'm sympathetic to the situation a little bit more. I'm going to go out of my way and work something out as far as the payment plan goes. Obviously, if you pay up front, the fees, you have a better shot of the fees going down low, because then I don't have to worry about turning my office into a collection agency. I'm a criminal defense attorney. I'm running a business, not a collection agency. So, I definitely offer payment plans. They need to be realistic, and I'll work with you as best as I can.
Okay, all right, that sounds fair. And the last question we had is, how long does a I'm assuming this person has a drug possession offense. How long does a drug possession trial take, and do I need to go to the trial if I hire you?
First part of that question, anywhere from 2 days to probably a month, depending on how much drugs are involved, how complicated the case is. And the second short answer, if it's a felony, 100% you need to be there. Although, after Prop 47 in November of 2014, few, if any, drug possession cases are now felonies in California. So if it's a misdemeanor with court approval under Penal Code Section 977, as long as you're in good contact with your retained attorney, you could appear, or any attorney for that matter, you could ask that the court appear without you there. However, if the case is going to trial, particularly a jury trial, don't you think it would be easier to convict an empty chair as opposed to a person? That's what I always tell my clients, particularly clients that I represent that may be out of state. I have no problem asking the court to represent you 977, which means you're not there. But from a juror's perspective, the 12 people that will be deciding your fate, it's a whole lot easier, at least I would think, to convict an empty chair as opposed to a person who's there, who's taking notes, who's conversating with their attorney, and who shows the jury and the court how much this means to them. And that's a dynamic sometimes, especially with these misdemeanor cases, particularly in drug possession cases or in DUI cases, where the client necessarily wants to go to trial, but he or she doesn't want to show up for trial. And that's tough. I mean, I have no problem doing that if that's what the client wants, but it's obviously in your best interest to show up for trial. As far as how long that case would take, it's a simple drug possession case. It may take longer to pick a jury than it would to put on the evidence. It all depends. Obviously, the government, since it's a simple drug possession case, it would be a state case. The district attorney or the city attorney, if it's a misdemeanor in downtown San Diego, has that burden. We, myself, and you, more importantly, as the accused, do not have any burden. You do not have any obligation to put on any evidence. So, for the most part, how long the case will take is depends on the government, depends on the city, depends on the state prosecuting agency, more than it does on us.
Okay, that makes sense. Well, that was the last question. Again, if you're watching this, have any questions for David, feel free to post them down to the comment section of the YouTube video. Obviously, feel free to reach out to him. And David, thanks for your time.
Sounds good. My pleasure.